Good afternoon and welcome to the Public Service Commission of South Carolina. It is Thursday, May 2nd at 2:34 p.m. We are here for oral arguments, and I will recognize our staff counsel, Ms. Mosier, to read the docket.
Thank you, Madam Chair. Good afternoon, commissioners and parties. We are here today for an oral argument in docket number 2023-388-E, which is the application of Duke Energy Carolinas, LLC, for an increase in electric rates and charges, and docket number 2023-403E. The oral argument is regarding the Office of Regulatory Staff's motion for a declaratory ruling and a motion in limine, and the proceeding has been scheduled for today, May 2nd, 2024, following the conclusion of the Commission's business meeting. Madam Chair, I believe all the parties participating in this matter are available and the docket is in order. Thank you.
Thank you, Ms. Mosier. Let's take appearances from the parties. We're kind of going in a reverse order today because of the movement, but I do need to do a roll call. Thank you. Getting out of order here. Let's take a roll call of commissioners. With us virtually, we have Commissioner Carol Lee Williams, President of the hearing room. We have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Caston, and Chair Belser. Now let me get to the parties. Who's here representing the movement, South Carolina Office of Regulatory Staff?
Good afternoon, Madam Chair, Vice Chair Powers, and Commissioners. Chad Torrey on behalf of ORS.
Thank you, Mr. Torrey. And the respondent, Duke Energy Carolinas?
Good afternoon, Madam Chair. Lyle Trawick along with Kamal Robinson for Duke Energy Carolinas.
Thank you, Mr. Trawick. And South Carolina Department of Consumer Affairs.
Good afternoon, Madam Chair, members of the Commission. Roger Hall on behalf of DCA. Thank you.
And I note that we have no one from the Energy Users Committee, the Small Business Chamber of Commerce, Coastal Conservation League, Southern Alliance for Clean Energy, or Vote Solar, CMC Recycling, or Walmart. Has that got everybody that's here? Mr. Torrey, you're first. Thank you, Madam
Chair. Again, good afternoon, Madam Chair, Vice Chair Powers, and Commissioners. I appreciate y'all taking the time to hear this issue today. One component of the Duke Energy Carolinas rate case that's pending before you is recovery of costs that it has incurred to close the coal ash basins that it has in North Carolina and one in South Carolina. Now, the company is asking for recovery of costs incurred since its last case, which I like to think of as new spend, but it's also seeking recovery of basin closure costs this commission disallowed in the company's 2018 rate case, and I'll refer to those costs as disallowed costs. Now, ORS's motion before you is applicable to only the disallowed costs. It has nothing to do with the future spend. In the company's 2018 rate case, the commission disallowed on a system level $469,894,472 in coal ash basin closure costs. That amount was based on disallowances at 3 of the company's facilities. $116 million at Dan River, and I'm rounding, $36 million at Buck, and $316 million at River Bend. The commission found the disallowed costs were incurred by the company to comply with North Carolina's Coal Ash Management Act of 2014, or CAMA. In its order, the commission stated that it had, quote, received evidence that confirms that North Carolina's CAMA is much more stringent and results in costs in excess of those that would be incurred absent CAMA. That's the Commission's Order 2019-323 at page 25. The Commission stated that it would, quote, not permit DEC to pass on increased expenses incurred as a result of North Carolina's CAMA. That's page 25 of the Commission's order. Accordingly, the Commission found it, quote, just and reasonable to disallow the recovery of additional expense attributable to CAMA from South Carolina ratepayers. That's page 26 of the Commission's order. The company sought rehearing. The Commission rejected the company's allegations of error, concluding, quote, its, quote, decision to disallow recovery of $469,894,472 in coal ash remediation and disposal cost was supported by the substantial evidence on the whole record. That's on page 8 of Order 2019-455. The Commission further stated in its rehearing order, quote, North Carolina's CAMA rules resulted in additional expense being incurred at several of DEC's facilities due to accelerated closure schedules that the federal CCR rule did not require, or closure requirements that the federal CCR rule did not require. That's on page 9 of the rehearing order. DEC appealed this Commission's decision. The South Carolina Supreme Court affirmed this Commission's order in Duke Energy Carolinas LLC versus South Carolina Office of Regulatory Staff, 434 South Carolina 392, and that's in 2021. Now, despite the plain terms of the Commission's order, its order on rehearing, and the opinion of the South Carolina Supreme Court, the company has simply resubmitted in the present case for recovery $153 million of the disallowed costs. The company's refusals to accept the finality of this Commission's decision runs afoul of the fundamental principles of collateral estoppel and res judicata, prohibiting a party from relitigating in a subsequent case an issue or claim on which it lost in a prior case. Truly, those foundational principles provide the beginning and the end of the analysis here. Yet, the company goes to great lengths to fashion an argument that is entitled to have the disallowed costs taken up again in this case. In support of its entitlement to a second bite at the coal ash recovery cost apple, the company first improperly conflates the Commission's order in DEC's 2018 rate case and the order in DEP's 2018 rate case. They are not the same orders. Indeed, in its comparable motion for declaratory ruling that ORS filed in DEP's 2022 rate case, ORS acknowledged that, quote, in its order, the Commission did intimate that future circumstances could offer the company the opportunity to resubmit for recovery in future proceedings the costs that it disallowed. In particular, the Commission stated, quote, however, should our General Assembly or the federal government enact laws that impose costs currently only imposed by North Carolina's CAMA, DEP is not prohibited from seeking recovery of such costs which, at present, we disallow. Now, ORS showed in its motion and reply in the 2022 DEP rate case that even assuming the Commission's 2018 DEP order contained a door through which DEP could resubmit in its 2022 rate case the coal ash closure costs that this Commission disallowed in DEP's 2018 rate case, that door remains securely closed. Now, critically, the Commission's 2018 DEC rate case order does not contain any of the language that frankly caused ORS to acknowledge in its brief that there may have been a door left open in DEP. The order's disallowance of the coal ash closure cost is plain and it's unequivocal. But let us assume that the Commission's 2018 DEC rate case order did contain some type of caveat that arguably entitles the company to come back 6 years later and resubmit for consideration the cost that you disallowed in 2018. Let's just assume. The company still completely fails to provide the Commission with any relevant facts or argument that would support the disallowed costs being part of this case. The company claims that the federal CCR rule, and that's the Coal Combustion Residuals Rule that Environmental Protection Agency promulgated in 2015, is subject to an interpretation by EPA today that is quite different from the interpretation that the regulated community understood back in 2018, close quote. That's company's response, page 2. Now, as an initial matter, the EPA's new interpretation that's relied upon by the company continues to be challenged by industry groups and utilities in a case pending before the United States Court of Appeals for the District of Columbia. So that interpretation upon which the company so heavily relies for its argument is far from settled. But regardless, even if EPA's new interpretation of the CCR rule was settled law, which it's not, it would not impact this case. The company claims that under the EPA's new interpretation of the CCR rule, the, quote, cost to comply with an alternative CCR rule compliant closure methodology would exceed what DEC actually incurred, close quote. That's response, page 3. Now, the CCR rule provides two methods by which the owner or operator of a CCR surface impoundment can close it. They can excavate the ash, or they can close it in place. The company claims that at its Dan River site, closure in place in accordance with EPA's new interpretation of the CCR rule, quote, make that option much more expensive than the option actually chosen by DEC, close quote, response, page 3. In other words, the company is saying that under the EPA's new interpretation of the CCR rule, which is not settled, but let's just assume it is, if the company had to close in place its impoundments at Dan River, it would spend significantly more money. I submit to you that that is completely irrelevant. The option of closure in place at Dan River was taken off the table when the North Carolina General Assembly enacted CAMA in 2014. CAMA expressly called out Dan River as a high priority site that had to close by excavation. As a matter of North Carolina law, the coal ash basins at Dan River today and for the past decade cannot be closed in place. Thus, any comparison of costs the company actually spent to close Dan River by excavation with what it estimates it would cost to close Dan River in place now under EPA's still to be challenged interpretation of the CCR rule is simply a theoretical exercise that's completely devoid of reality or any relevance to this case. Similarly, the other plant at issue here, Buck, was also required as a matter of law, North Carolina law, to close by excavation. In July 2016, the North Carolina General Assembly enacted House Bill 630, which added to CAMA the requirement that DEC, together with DEP, identify 3 sites at which to install and operate ash beneficiation projects. 2 months later, on April 28, 2016, DEC entered into a mediated settlement agreement with environmental groups, settling claims against the company for violations of the Clean Water Act at Buck. The mediated settlement agreement stated as follows, quote, based upon Duke Energy Carolina LLC's intent to announce its plans to remove all coal ash from the 3 ash basins at Buck for processing for cementitious purposes under the provisions of the North Carolina Coal Ash Management Act and House Bill 630, the parties agreed to resolve the litigation, provided DEC remove the ash from the Buck basins for beneficiation. And one week later, Duke Energy announced its selection as Buck as one of the 3 sites at which it was going to be doing this beneficiation required by CAMA. So, as with Dan River, as a matter of law, the coal ash basins at Buck today and for the past 7 years cannot be closed in place. Now, let's look at the reasons this commission disallowed some of the closure costs at Dan River and Buck in 2018. The commission noted, quote, witness Whitliff identified Dan River as a DEC site that has been affected by the accelerated closure timeline imposed by CAMA. He testified that under the CCR rule, the company would not have been required to commence closure activities until October 31st, 2020, while closure under CAMA is required to be completed by August 1st, 2019. That's order page 50. To put that August 1st, 2019 closure completion date in perspective, the company projects that it will complete closure by excavation of the ash basins at its other North Carolina plants as follows. Allen, 2037. Blues Creek, 2031. Buck, 2035. Cliffside, 2028. Marshall, 2034. The costs incurred by the company for the accelerated closure at Dan River were 100% a result of CAMA, plain and simple. Those are the costs the commission disallowed in the 2018 rate case. Those are the costs the company is seeking a second bite at the apple at in this case. In addressing Buck, the commission stated in its order, quote, ORS recommends a disallowance of $36,544,788 at Buck for ash beneficiation costs, which witness Whitliff testified would not be required under the federal CCR rule. That's order page 49. The costs incurred for the company for its beneficiation activities at Buck were 100% a result of CAMA, plain and simple. Those are the costs this commission disallowed in the 2018 case, and those are the costs DEC is asking you to look at again in this case. Commissioners, those last two statements were the operative facts in 2018, and they remain the operative facts in 2024. Thank you very much for your time.
Thank you, Mr. Torrey. I don't know if commissioners want to ask questions now or at the end of. The end? Okay. Thank you. Mr. Trawick or Mr. Robinson?
Thank you, Madam Chair. My esteemed co-counsel is going to put something up on the Elmo and pass something up to the commission, if it pleases the commission, and Ms. Wheat. It's just a demonstrative setting forth some key principles here. Beg the commission's indulgence as we try to wrestle with technology. Okay. Madam Chair, members of the commission, we appreciate the opportunity to respond to ORS's motions here today. I want to start with a couple just level-setting principles. We're not here for any reason other than ORS teed the issue up this way in 2018. As the testimony up on the board shows, witness Whitliff said, when asked, "Are you recommending that DEC be precluded from recovering costs disallowed in this proceeding and future proceedings?" Not necessarily. And if the conditions are met that he outlined, he said that they should be considered for recovery. The Supreme Court, in its opinion, said the PSC has left the door open for Duke to potentially recover CAMO-related costs in a future proceeding. Not DEP, not DEC, Duke. Duke was a previously defined term in the opinion that Acting Chief Justice Kittredge authored, and no distinction was made in that footnote. And again, the court noted that the PSC emphasized several times that the disallowance of CAMA costs was only its decision at this time, and future developments could change its position. So against that backdrop, ORS's attempt to invoke the doctrines of collateral estoppel and res judicata in this setting is misplaced. We're here because the Supreme Court said that this commission left the door open for the commission to take another look at these costs if federal law and circumstances change. Now, I would note, we wouldn't even be here if these plants weren't in North Carolina. Every single utility in South Carolina executes their coal ash removal by closure by excavation. And the use of beneficial reuse is also hardly novel or gratuitous. In fact, as our witnesses, which we want to put before you, and they're eager to have these conversations with the commission, will show, around 2/3 of CCR is going through the process of beneficial reuse as of the last time it was measured in 2017. It was about 64%. Dominion, in its last rate case, ORS said nothing about Dominion's use of beneficial reuse that I can find, and Dominion was able to recover those costs. Santee Cooper uses beneficial reuse, and that's an arm of the state of South Carolina. So South Carolina has been an industry leader in beneficial reuse. So the attack on that seems a little misplaced here, and only because it also appears in North Carolina. But I want to also start, so the finding in the 2018 rate case was not that the company did something imprudent or unreasonable. It was a focus on costs. And because it was the cost recovery piece of that, the Supreme Court said that this commission left the door open. And so when you look at it that way, there's no finality. That's putting a pin in it. And so we have the right to come in here and ask for it, and at a minimum, put them for you for consideration. They want to short circuit that and not allow the company to put forth the first bit of evidence to show why they're prudently incurred, to show why the law and circumstances have changed. And I would note on that point, ORS's own witness, Whitliff, has a sea change in his attitude on closure methods. He basically said that closure in place was the gold standard in 2018. And now he's quickly moved on to closure by excavation. Why is that? Gavin. So in Gavin, the EPA clarified that engineering controls that are extensive and frankly expensive must be in place if you do closure in place. So the analysis is fundamentally different now. Another thing that's fundamentally different, the methodology by which ORS witness Whitliff calculated his proposed disallowances last time was not really subject to any scrutiny or challenge to the reliability of it. It frankly was picking something out of thin air. He does it now, and he has not even performed the task that ORS charged him with, which was to calculate incremental costs. Those issues belong in a factual setting before the commission. I heard my friend on the other side, Mr. Torrey, mention that the facts are not in dispute. With all due respect, there's not any facts in this record, although the company and the parties have pre-filed direct, rebuttal, and surrebuttal testimonies. None of that's been admitted into the record. So to short circuit a hearing, a plenary hearing to determine the merits of this issue would be, respectfully in my view, reversible error. It would be arbitrary, and it would also be an abuse of discretion. Instead, the better course to chart here is to hear all of the facts and make a determination in a final order. Although not styled as such, this really strikes me as a motion for summary judgment that a party would file in circuit court. They want you to decide as a matter of law. But for the reasons I just said, that's not really the proper procedural vehicle here. They're asking you to decide something as a matter of law without the benefit of any facts. There's no verifications, there's no affidavits, there's no admitted testimony. They just want you to decide all of it in the law and the facts according to Mr. Torrey. A lot of what he said earlier sounds like great testimony. And again, our witnesses stand ready to have those important conversations in the rate case hearing. But to decide it now would be inappropriate. Now, ORS in its reply mentioned the words collateral estoppel and res judicata one time. They did not attack, they did not wrestle with, they did not disagree with any of the exceptions to those doctrines that the company invoked, and therefore forfeited any argument on those. But they're really important. The courts have been very clear that courts and even this body should not rigidly or mechanically apply the doctrine of collateral estoppel, and that res judicata is not an ironclad bar to looking at issues. The exception that we would invoke under Rule 26 of the Restatement Second that was in our brief, when a court leaves the opportunity for it to be litigated again, that's a notable exception. That's what we have here. You have the Supreme Court of South Carolina saying the door was left open. Even if the commission were to disagree with that, that's what the Supreme Court said, nil ultra. And so that's the rules of the road that we're stuck with. And so for those reasons, we don't think that collateral estoppel or res judicata are appropriate here. Also, there's a public policy exception that we cited in our brief and countervailing considerations that necessitate relitigation. And for all those reasons, collateral estoppel and res judicata really are inapposite in the rate case setting. Last, on the issue of whether we properly showed a change in circumstances, that is 100% a factual issue. And I heard Mr. Torrey mention that it's a factual and legal issue. That's something that you need hearing evidence on and not decided in this truncated posture with no evidence and just the law according to Mr. Torrey. Just because they say it doesn't make it so. And so for these reasons, I believe that the commission should deny the motions. We explained in our brief that the motion in limine also doesn't really raise any proper evidentiary bases on which to strike the company's coal ash witnesses. And so although they say it's irrelevant, it's not. He doesn't get to determine what's relevant. That's this commission's job after a full presentation at a hearing on the merits. And I welcome the commission's questions because obviously there are a lot of convoluted issues here as presented, and we want to answer anything that you may have a burning desire to inquire about.
Thank you, Mr. Traywick. Wait just a minute. Mr. Hall, I don't think you plan to put an argument forth, do you? I don't mean to put you on the spot, but I don't want to leave you out.
No, Madam Commissioner, the
Okay.
department supports ORS's motion, but we have not submitted any pleadings.
Okay.
Thank you.
Thank you. I'm gonna open up for questions for both attorneys. I don't know who's gonna be asked first or if you're gonna be asked together, so.
Madam Chair, I do wonder if I might have a moment to reply.
Yes, sir. I figured you'd already done that because you covered your reply brief. And
Well,
that's fine.
Mr. Traywick's
that's
raised some
my-
additional issues.
That's my fault. You go ahead, Mr. Traywick. You can sit down. We'll bring y'all both back up after Mr. Torrey. Not trying to shut you down, Mr. Torrey.
Thank you, Madam Chair.
And that's what I get for assuming.
I didn't know that I made so many findings of fact in my initial presentation, so please do accept my apologies. Mr. Chadwick says that ORS teed, we're here because ORS teed this issue up in 2018. And it cites testimony that ORS witness Whitliff made, and that made it into this commission's order. Now, it's only one sentence that made it into this commission's order, but it's there. And it says if the commission, if DEC can show that it is subject to expenses attributed to the CCR rule in the next rate case, separate and apart from CAMA, then yes, then it should be allowed to come back and resubmit those costs. Now that is a paraphrase, but that's what he said. Okay, let's assume that the door is open. Let's assume the Supreme Court left the door open, though I think it's plain that they were talking about the DEP order. They consolidated the two appeals. The "at this time" caveat, in fact, in the company's responsive brief, I compared it to their responsive brief in the DEP case. And in the DEP case, they said, quote, "ORS's position in the company's last case, however, was accompanied by a large caveat. And as explained below, the Commission and the Supreme Court of South Carolina accepted this caveat. By comparison, if we look at DEC's response here, they wrote something very similar but different. ORS's position in the company's last case, however, was accompanied by a caveat, no longer large, but I suppose still a caveat, that the Supreme Court of South Carolina also accepted. Now, not willing to agree that the Supreme Court accepted that caveat, but apparently the company doesn't believe this commission accepted the caveat. Why the change in language? The sentences are almost identical. The "at this time" language that, I don't know how to use this thing, but y'all saw it. The commission, the Supreme Court said,
Take your time, Mr. Torrey.
okay, thank you, sir. Oh yeah, y'all have it. The PSC emphasized several times that the disallowance of CAMA costs was only its decision, quote, "at this time," and future developments could change its position. And that's the Supreme Court's opinion at page 412. I challenge the company staff, find me, quote, "at this time" language in DEC's order. You're not going to find it. Even assuming there's a door open, it's still the company's burden to show that the conditions associated with that door have been satisfied. It's not good enough to just say, well, the Supreme Court said we can come back, so here we are. That's not it. That's not what they said. They said, if the company can show that something has changed in the world, whether it be with the CCR rule, Congress enacts something, the South Carolina General Assembly enacts something that puts cost burdens upon the company, that are separate and apart from CAMA, okay, then maybe they should be able to come back. Mr. Trawick didn't explain to you what that thing is. That thing doesn't exist. It's an illusion. Thank you.
Thank you, Mr. Torrey. You might want to just stand there. Mr. Trawick, I'd invite you to stand there. Commissioners, questions for council? Vice Chair Powers.
Thank you, Madam Chair. Mr. Torrey, let me start with you, if I could. I'm glad you're standing there because I can't see you behind that bench. This position that you mentioned earlier about the $469 million in disallowance, that was the position of ORS at the time of that hearing, was it not?
That's correct.
Okay, because, you know, some of us, well, I wasn't here. And there are, in this case, there's other substantial coal ash costs that we're to consider and put a number on. Is that correct?
That's correct, Vice Chair. I believe the the overall ask on a system level in this case is $1.16 billion. On a system level, 158 million of that is these disallowed costs.
Okay. Regardless of if there's a change in the EPA's interpretation, does that matter as far as the law itself, if the law hadn't changed?
Well, to answer your question, the interpretation of the CCR rule upon which the company 100% relies, without this interpretation, they're not here before you.
Okay.
First of all, has been in litigation since April of 2022. It's before the DC Circuit. Industry groups immediately challenged the EPA when in January of 2022. It didn't go through a rulemaking, didn't issue a call for notice and comment. It issued a press release. It issued letters to utilities, including one to Duke Energy Indiana. And it issued several proposed denials of requests from utilities to extend deadlines. And in those documents, it became clear that the EPA was now taking the position that if an impoundment has ash in contact with groundwater, the option to close in place is only available if you effectively are able to entomb this ash on all four sides so that no groundwater still in the ash can ever get out and no groundwater outside can ever get in. That's the EPA's quote-unquote new interpretation. And we don't know what the DC Circuit's going to do, but I submit to you it doesn't matter what the DC Circuit does.
Okay. Well, I guess I got a problem with a different interpretation and the term change of circumstances. The circumstances remain the same, do they not? They dumped 780 million pounds of coal ash into the Dan River, several hundred million coal ash water, and they pled guilty to it. They're criminally liable. And I don't know, I grew up watching Perry Mason. I'm a former prosecutor. I think Commissioner Williams has been a prosecutor, and the chair has been a prosecutor. You know, change of circumstances in a criminal case kind of like, to me, was like Perry Mason when somebody stood up in the back of the room and said, I did it. Once you plead guilty, nobody stands up in the back of the room, and I think there's some real concern there. But I think what we're trying to understand too is what exact, are you trying to eliminate these three witnesses or just eliminate their testimony as to this portion of coal ash? I mean, there's other testimony that we've seen that they have.
And that's a great that's a great question, Vice Chair. What ORS is seeking is a ruling from the commission that, as a matter of law, the company is not entitled to seek recovery of these disallowed costs in this present rate case. And in conjunction with that, exclude the testimony of the Duke witnesses that opine or discuss these disallowed costs. And I've prepared a list of the actual page and line of the witnesses that we would ask be excluded.
Okay. Well, you know, we sit as judge and jury, so it's kind of a different way of having to look at things. But you can show what exact portions you're trying to exclude if this motion was granted.
I can, sir.
I don't need it right now.
Yes, sir. I've got a list of page and line that of direct and rebuttal Duke witnesses that we would ask be excluded. But to your point, Vice Chair, since this isn't a jury trial, obviously, if the commission were to issue a ruling that these disallowed costs cannot be considered in this case, frankly, it's probably a moot point whether we go through the extra exercise of excluding that testimony or not.
Okay, well, that makes sense. When this thing happened and was litigated, there were fines, significant fines paid to North Carolina. And I guess because the river was in North Carolina, and I looked at a map, it looks like it goes through Virginia too. Were fines paid to Virginia, or do you know?
Vice Chair, I believe that as part of the plea agreement, DEC agreed to pay to a criminal fine of $52.5 million. Now that was a fine that didn't go to any particular state, but it was also ordered to make restitution to the town of Eden, where this plant is, and associated groups that were truly impacted by this, and some of them were in Virginia. Yes, sir.
Okay. Well, when there's criminal liability, should it be the responsibility of the ratepayers or the stockholders to assume?
Well, I do want to clarify, Vice Chair, that we're not, ORS isn't taking the position that yet the facts are that DEC pled guilty to nine counts of criminal negligence. The facts are that. That was also a while back. It was almost a decade ago. So the costs that were before you in 2018 did not the disallowance of those costs was not based upon the fact that the company committed criminal acts. It was based upon those costs being a direct result of the obligation to comply with North Carolina's CAMA, as opposed to the federal CCR rule.
Okay. All right. Thank you, sir.
Thank you.
Further questions for council?
I didn't know if somebody else wanted to go ahead and question Mr. Torrey. I reserve possibly talking
Okay.
to Mr. Trawick later.
Well, you can, they're fair game, either one.
Okay, well, I'll go ahead then. Mr. Trawick, again, as you've heard me say, some of us have been prosecutors, former judges, in different situations. And I'd ask you the same question. When there's criminal negligence, was this stuff done at night, or was it done in the daytime, or how was it snuck in the river?
Vice Chair Powers, we're not here to relitigate that portion of it as not to I don't want to dodge your question. Okay, I don't know. I have not dug deep into the criminal negligence aspect of it because that was not even part of the 2018 rate case. none of those costs were at issue. What was at issue then that ORS recommended a temporary disallowance of that's at issue now are environmental compliance costs, not what caused, what in their view caused CAMA or what led to the situation. But now that now that coal ash has to be removed, consistent with EPA requirements and state law, what reasonable and prudent costs can the company recover?
So you think the fact that it was criminal, somebody pled guilty to criminal behavior is irrelevant to now wanting money back?
Vice Chair Powers, that's not what I'm saying. I'm saying the Supreme Court already took all of that into account, and so did this commission last time in attributing cost to CAMA. What we're looking at here is a different question. It's what is the incremental cost difference? So it's a narrower issue. I mean, we acknowledge all of that occurred. Those are the facts, and I'm not trying to downplay it in any way, right? It was a serious matter, but that's not the issue before the commission right now.
Well, there's no question this particular money has been litigated and taken all the way to Supreme Court, was it not?
Correct, with the door left open on in the next rate case for these specific costs.
Okay. Knowing it's been litigated, is this not just included as something that can be a bargaining chip by Duke?
No, Vice Chair Powers. We are following ORS's lead. They have very bright attorneys over there. They review all their testimonies that are filed, and this is what ORS witness Whitliff said in the last rate case. It was acknowledged by the commission. I do want to go there for a minute. The DEC and DEP rate cases were tried in tandem. It was the same witnesses, the same record, the same evidence. And so this splitting of hairs post hoc seems a little disingenuous to us, particularly in view of the fact that the Supreme Court talked about Duke collectively. So I did want to make that point. But no, we don't think so.
Well, I mean, it occurred, it was wrong, it was litigated. I mean, 3 strikes in baseball, even Lee Bailey can't get you back in the game. Anyway, you're saying that the shareholders, though, should not bear this cost, but it should be borne by the ratepayers.
So not all costs are at issue, right? I mean, we're not dealing with the cost of the penalties and all that. I think, as I understand, the shareholders have already.
I know we're talking about a certain amount, but you're saying that certain amount that has already been litigated should be borne by the present ratepayers rather than the shareholders.
Yes, because it was deferred as a regulatory asset, and now they're back properly before the commission.
And the commission didn't set up a deferral account at that time, did they? Or require one?
My understanding is that was the case, Vice Chair Powers, subject to check.
Why would this not be retroactive rate making?
For a couple of reasons, Vice Chair Powers. I'm glad you asked that. So it was given regulatory asset treatment, never included in the rates, and are being appropriately assessed in this rate case for potential inclusion of prospective rates. And so no one's questioning the reasonableness or the prudence of the activity. We're looking purely at cost. In light of the changed circumstances and the EPA's guidance, and again, that's a factual issue. I understand that, and he wants to say, well, it's subject to appeal. Well, guess what? Anytime anything ever happens in regulatory space, particularly with respect to the EPA, it gets appealed. But guess what? The rule is still in effect. And although it's a site-specific analysis, it's a clear signal to the regulatory community that if you don't have the requisite engineering controls on site, that's going to be a problem with the EPA. And so to not follow that guidance and do closure in place without those engineering controls in place, in our view, would be imprudent.
Okay. Regardless of this interpretation, there's been no change in the law in South Carolina, has there?
In South Carolina, no.
Okay. Thank you. That's all I have, Madam Chair.
Thank you. I'd like to, you just said that these cases were tried in tandem. They were tried separately though, right? Back to back.
They were, Madam Chair.
And then the appeals were consolidated. I don't know who said who wanted the appeals consolidated, but the appeals of both cases were consolidated before the Supreme Court.
Correct. And
Okay.
and I wasn't trying to be misleading by saying in tandem, but I mean, it truly was essentially the same record. Obviously, costs were different, but it was the same witnesses. Whitliff was in both cases. And so
I just
also-
was confused by the word tandem because I didn't want there to be, the majority of the commissioners weren't here then, but I didn't want there to be a misunderstanding that they were somehow tried together or consolidated. But
No, they were not.
They were tried back to back. You'd
Correct.
agree with that?
Correct. It was a
Okay.
long month from my understanding.
Thank you.
Madam Chair, if I could raise one point of order on something that Mr. Torrey said earlier about furnishing citations to the testimony he wants stricken.
Yes, sir. Y'all haven't seen it.
No, and the commission has often followed appellate practice, and a fundamental tenet of appellate practice is when you raise a conclusory matter in your brief, it's waived. We, in our response and opposition, said we don't even know what portions they're seeking to strike, and so to not even address it in reply, come up to the hearing and still not address those at this late hour, respectfully, that argument's forfeited, and we would object to not having the opportunity to respond to it.
Okay. Mr. Torrey, you want to respond?
Yes, absolutely.
Just giving everybody a fair shot here.
This commission issues an order that the company is barred from seeking recovery of the $158 million of costs that this commission disallowed in the 2018 rate case. Duke has some smart lawyers too. We can figure out what testimony doesn't need to come in. It doesn't matter at that point. It just doesn't matter.
Thank you. Commissioners, questions? Commissioner Caston, I see your light on.
I think Commissioner Justin Williams. Okay. Thank you, Madam Chair. I'll ask you, Mr. Trawick, and I guess if you want to respond after that, Mr. Torrey. Do you believe the EPA's interpretation amounts to a change in the law?
So the rule itself has not changed, but the EPA, which is the agency charged with interpreting and enforcing the rule, has announced a clear interpretation to which the regulatory community is subject. And so has Congress passed a law? No. Has EPA engaged in a rulemaking? No, but they do have the authority to interpret their rule, and that's what they've done here. And so I think in that sense, it's not a change in how a bill becomes law, but it is a change in circumstance, which was included in their forecast in Whitliff's testimony in the 2018 rate case about a change in circumstances that would warrant a review or a new look at these costs.
And I think Mr. Torrey alluded to this, but is this change in interpretation a settled issue?
It's not, but until a court of competent jurisdiction strikes it down, it's the rules of the road for utilities to not follow at their own peril and at great expense.
Okay, the cost at issue in this matter were incurred prior to the adjudication of prior rate cases, correct?
Prior to the adjudication of the 2018 rate case, and they did not include, and Duke has never sought any costs related to the fines and penalties related to the Dan River spill.
How do you interpret the words "at this time"?
For right now, we're putting a pin in it. And that, coupled with leave the door open, removes any doubt for me, Commissioner. And let me explain why. the Supreme Court of South Carolina, as noted on that sheet we gave you, has said the PSC is permitted to modify its existing policies or practices as it is not bound by its prior decisions, and it may re-examine and alter its previous findings as to reasonableness when conditions warrant. Conditions warrant it here for all the reasons that our panel of expert witnesses intend to explain to you, and in view of the fact that the Supreme Court, quote, left the door open.
Could it mean just that at this time, whenever I write this sentence, which was 2018, 2019?
Sure, that's not incongruous with our interpretation, though. It was at this time. I mean, I think we agree it means at this time. It's just what efficacy that has moving forward. And so absent any language of finality from the Supreme Court, that's why we're back here talking about it.
If there's a new administration, and in 2025, or 2026, 2027, whenever, if there would be a new interpretation that reverts back to what it is now, or maybe a lesser, would that mean, well, we would go with that one? We should go with that one? How could, if what the company is, I believe, arguing, if this is not retroactive and conditions change because an interpretation has changed, at what point do you stop using a new interpretation if there's a future change in that definition?
So, Commissioner Caston, that's a fair question. I want to be very clear. What we're asking for is very narrow. We are asking for the commission to honor the language of the Supreme Court of South Carolina. You can decide with finality in this proceeding, but that's not the way we read the order, and it certainly wasn't the way the Chief Justice-elect read the order.
So am I understanding you to say that what the existing interpretation was in 2015, which was during the previous rate case, are you saying that should not be applicable because in 2022, the EPA revised their definition of what that meant?
We're saying that that constitutes the change in circumstances forecasted by everyone for the commission to now come back and look at whether the EPA has caught up to CAMA. And because it has, with respect to closure in place, looking at the methods that the company employed, which is closure by excavation, which is uncontroversial, it's used by every utility in South Carolina, and the beneficiation process warrants recovery. And again, ORS teed this issue up that way. That's what their witnesses said. And so to come in here and say that the door was closed when you've got the next Chief Justice of South Carolina saying the door was left open makes no sense to us.
Okay, so acknowledging that this is not a settled issue, it is the company's argument that regardless of what the existing definition was at the time of the rate case, the previous rate case, that the commission should reconsider those expenses from the previous rate case based on the previous interpretation of that law.
The commission should look at it in view of how the EPA interprets it, because that was the circumstance contemplated there. Absent CAMA, would these costs have been required to comply with the EPA? And
I'm sorry, excuse me, please continue.
And so, in engaging in that analysis, as we and our expert witnesses would like to walk you through, is that under the new change in circumstances, these costs were properly recoverable from South Carolina and North Carolina customers because they're not CAMA only. That's another sort of buzzword that or buzz phrase, I should say, that I'd point the commission to that was all over its order, and that came directly from Whitliff's testimony. So they're no longer CAMA only.
Thank you, Mr. Trey. Mr. Torrey, I was not ignoring you. I hope you wrote all those questions down.
I did my best. Commissioner
If not, I might can remember them.
The first question I believe you asked is to Mr. Trawick was, what does quote at this time mean to him?
Well, I'm not sure of the first question, but it was a question.
It was okay. You have to catch me up. I'm not sure I know what it means either, and I'm not sure I need to know what it means. One thing I do know, and Mr. Trawick will accuse me of stating facts again, but I'm gonna. At this time is in your DEP order. At this time is not in your DEC order. And let's look at what the Supreme Court wrote. The PSC emphasized several times that the disallowance of CAMA cost was only its decision, quote, at this time, and future developments could change its position. Well, with all due respect, I don't know how. Yes, the case, the two orders were consolidated, but if at this time doesn't appear in the DEC order, I fail to see how that sentence can apply in this case. Now, Mr. Trawick said you were asking him about, I believe, the EPA's new interpretation, and basically where do we draw the line? If we get a new administration, it could change again. So does that mean they could just keep coming back until they get the one that fits their narrative? It's a great question. Mr. Trawick says, well, yeah, it's not final. It's still being litigated in the DC Circuit, but Duke, as being subject to EPA regulation, would be a fool to ignore what the EPA says the rule is. But I challenge Mr. Trawick to tell this commission what activities, what actions Duke either does or doesn't do from this day going forward that will run afoul of the commission of the EPA's new interpretation. There isn't anything. They've already done it. They've already closed these things by excavation. Some of them, Dan River, closed. They pay an engineer to model how much would it cost to close Dan River by cap in place. You know what? Applying the EPA's interpretation, it would have cost a lot more to close Dan River by cap in place than we actually spent to excavate it. So see, we were actually in compliance with the CCR rule all along. That's the argument, and that's fantasy.
Is ORS saying, or did I hear you say, in essence, and don't let me put words in your mouth, that regardless of what the interpretation was, or what it is, or what it may be, is not relevant because the work is already done? Is that what you were saying?
That's exactly right, Commissioner Caston. The issue at the EPA, okay, is if you have a surface impoundment, you've got an ash pond, and it has ash in contact with groundwater. Okay, how do you close it? Because CCR rule says you got one of two options. You can excavate the ash, or you can close it in place. So EPA still says, okay, you got ash in contact with groundwater, you can excavate it. But if you're going to close it in place, they want quote unquote engineering controls in place to ensure that there is no infiltration of groundwater, not only from the top, but the sides and the bottom. Respectfully, that interpretation as applied to Duke Energy Carolinas is a red herring. There's nothing they can do to comply or not comply with that rule right now.
Final question. Would ORS consider this retroactive rate making if this were to occur?
We didn't raise the retroactive rate making in this instance, Commissioner. It would be those calls, as Mr. Trawick mentioned, those calls weren't put into rates, but I don't think the commission needs to get there in order to conclude that these costs should be excluded from this 2023 proceeding.
I understand. Mr. Trawick, I think that was the only agreement I've heard so far.
And I appreciate it.
No more questions. Thank you, gentlemen.
Thank you.
Thank you, Commissioner. Commissioner Justin Williams?
Thank you, Madam Chair. Gentlemen, I don't want to be before you long. I just want a little bit of clarification. There's been a lot of back and forth regarding leaving the door open. Shout out to Bruno Mars. And the CAMA costs and the language at this time. So I want to go through the costs that are being asked for in this case. My understanding is that, and let me ask it this way. What coal ash costs does ORS not object to? Or are there any coal ash costs that ORS objects to?
And just to clarify that, Commissioner Williams, you mean as part of the disallowed costs?
Yes, sir.
So the disallowed costs were related to Buck, Dan River, and River Bend. Now, I don't think you've heard River Bend today, and that's because Duke has not made River Bend a part of this case. River Bend is what is called a legacy impoundment, and as of right now, it is not subject to the CCR rule. Now, and it won't be subject to the CCR rule until this commission has to render an order in this case. So at Dan River, what cost did this commission disallow? It disallowed the accelerated closure costs. So this commission accepted the testimony of witness Whitliff that the company incurred additional cost because it had to have Dan River closed by August 1st, 2019. So it had 5 years. 5 years to close this thing. And again, to put that in perspective, it's thinking it's going to take till 2037 to close Allen, 2028 to close Cliffside. So these things take time. So it was on an expedited schedule. It incurred additional costs. Those costs were because of the CAMA deadline, therefore they were disallowed. At Buck, CAMA was amended in 2016 to require DEC and DEP, between the two of them, select at least 3 sites to build a beneficiation plant. The company chose Buck as a beneficiation plant. It spent significant sums building what they call a STAR plant, which is a technology actually patented by a South Carolina company. And those costs that were disallowed in the 2018 rate case, witness Whitliff attributed to, and this commission agreed, were tied to projects and procedures and tasks undertaken by the company to get the beneficiation going. He allowed the other costs. He allowed costs at Dan River. He just didn't allow what he saw as costs that were tied to CAMA. And that brings me to one more point, Commissioner Williams, if I may. There is nothing that EPA can do to change the fact that CAMA required the company to close Dan River by August 1st, 2019. It's done. There's nothing they could do. They could do a rulemaking. Congress could pass a statute. I don't know how you unring that bell.
Right, understood. So you got those disallowed costs. Are there other costs in this rate case associated with coal ash?
Yes, sir. Now, again, when I remember, I said there's disallowed costs, and that's what this motion is about.
Mhm.
But so that's $158 million of the $1.160 billion the company is asking for in this rate case.
Understood. And this may seem like a strange question to you, but I'm trying to understand something. You object to what you describe as the disallowed costs. Is that correct?
That's correct.
Okay. Why don't you object to the other costs?
To the other costs,
Other coal ash costs?
well, we very much do, and we'll be litigating that issue before you. But that's not part of the ORS motion. The ORS motion is limited to the disallowed costs.
Right, and this is what I'm trying to figure out. CAMA is still good law, right?
It is.
Okay, and the company's operating under CAMA to the best of your knowledge, subject to chat.
Yes.
Okay, so could it be? And you're not, as it stands today, you're not objecting to those the balance of that $1 billion plus coal ash. You're not coal ash costs. You're not objecting to those. You're objecting to the approximately $158 million.
Well, let me
in this motion.
in this motion, it's the
motion, yes, sir.
$158 million.
In
Now
this
you'll
motion.
see in our testimony that
Right, I got you. I'm
Okay.
sorry. Let me be more specific. What stands out to me, and I could be totally off base, when I hear the language left the door open and at this time, it stands out to me that there were more costs associated with coal ash to come after that decision was made in 2018, 19, whenever that was. And so knowing that, the commission, you could argue, and maybe let me ask you a question. Is it possible that the door that was left open was to consider any cost that was to come before the commission subsequent to that particular ruling and not necessarily related to the cost that was disallowed in that actual case?
100%.
Okay.
And in fact, if you go back and read the transcript, Commissioner Williams, you'll see that witness Whitliff talks a lot about River Bend.
Right.
Because River Bend was not subject to the CCR rule. It's a lot of money. And he said, I'm not saying you don't ever get your money, but you don't get your money now because it's not subject to the CCR rule.
Thank you, sir. Mr. Trawick, do you have any response to that? I don't know if you understood the line of questioning.
Sure, of course. So first of all, on Riverbend and this notion of the EPA legacy impoundments not being in effect, I guess they might have missed that press release on April the 26th that does subject. EPA did do a final rule on legacy impoundments, and that cemented the alignment that EPA, DHEC, and the DEQ of North Carolina have on closure in place and the engineering controls. Putting that aside, the amount of cost at issue here, I don't believe it's 158. I think it's 153 for the previously disallowed costs, and then on the South Carolina retail basis is $249 million. As to where there are areas of dispute, it's really only Buck and Dan River. As I read ORS's testimony, they don't really object to any of the other 2018 to 2023 costs submitted for recovery here. So it's not fantasy because closure by excavation in the long term is the better method. And you'll see that in scores of pages, maybe not scores, but many pages in our witnesses' testimony. That's the better option for the future, so much so that Whitliff now says so. That's the baseline against which he wants the commission to judge current costs. Last time it was closure in place. So that's a fundamental change. And even him changing what he thinks the baseline is suggests that he thinks, okay, this engineering control business isn't just something that we can cast aside without any due diligence on it. So I hear you on the at this time language. I think in part that certainly was it, but that's not what the Supreme Court said. And it's not what Whitliff said. He was a little more forceful about the types of costs he was talking about, and they were the ones at issue in that case. And again, I have yet to hear ORS wrestle with the fact that its own witness proposed this framework. And so I don't think they can bury that testimony. I don't think they can whistle past the statements of the Supreme Court. And I think that we're back in front of the commission in a proper posture. Now, is it normal to have issues come up again in rate cases? Of course. Rate cases are like Groundhog Day, right? You come up with the same issues, and even parties who lose issues before make their same arguments again because the facts change, right? And that's all we're seeking to do here. And I'm glad that Mr. Torrey recognized the retroactive rate making isn't a concern. And then just another thing, the notion of this decision being final, collateral estoppel and res judicata don't really apply here because we're not suing anybody, right? Like the purposes undergirding those two issue and claim preclusion doctrines is so that someone doesn't have to be subject to the same suit twice. Here, the company is applying to the commission to recover its reasonable and prudently incurred costs and a reasonable rate on return. And so it's really just a fundamentally different setting. And I think that the court recognized that, again, with the language I quoted on the sheet and to the commission earlier. You can re-examine things in certain circumstances. And with all due respect, we think those circumstances have triggered another look here.
I understand all of that, and thank you for that. I'm just focusing on your handout here on the last quote on the page that in bold it says left the door open, and Duke is also in bold to potentially recover camera-related costs in a future proceeding. I mean, just reading that sentence, what stands out to me as a question, and I asked Mr. Torrey, and I'm asking you, is it plausible to interpret that as the opportunity for your client to recover camera-related costs that are outside of the costs that were examined at the time in this rate case? Is that not a plausible explanation or interpretation of that sentence?
In part, Commissioner Williams, but that's not the full picture, right? And it's got to be judged on what was in the record, what the commission decided, and that's not what Whitliff said. It's not what was included in the order, and I don't understand the need for at this time. I mean, if you want to go a step further and say, recognizing the law may change, future costs could be subject to a different analysis, but that's not what it said. And I think the absence of the more clarifying language that would support the interpretation you're inquiring about suggests that it was an adoption, in fact, of ORS witness Whitliff's testimony. And the commission did, in fact, in the DEC and DEP cases, find his testimony credible and went with his costs.
So stated another way, we did it to ourselves.
I'm not saying that. I'm saying you accepted ORS's testimony, and the Supreme Court read your ruling that way.
I hear you. That's all I have, Madam Chair. Thank you, gentlemen.
Thank you.
Commissioners, Commissioner Thomas?
Thank you. And I have a question about the deferral of this, whatever it is, 153 million or 158 million. That word's been used, but I'm trying to figure out, has this commission taken some action that said that money is deferred. And I'll ask you first. I think that
Commissioner Thomas, the commission's order was to disallow the 158, 153, whatever, $150 million. So since there was an out-and-out disallowance, there would be no need to have a deferral for those costs.
okay. And if there had been, then the commission would have taken some sort of an action to say, this is deferred, not disallowed.
That's correct. As the commission is aware, the company has a lot of deferrals, so it knows how to get a deferral if it wants one.
Okay. I think that's all I have.
May I respond, Commissioner Thomas?
Sure.
Yeah, it's my understanding that we requested a deferral and received approval. And so that is not factually accurate.
Well, may I respond?
And in fact, I think if I recall correctly, RS's testimony here is that deferral should end. And so that certainly suggests otherwise.
Yes, they certainly have a coal ash deferral. The $1 billion that you're about to hear about in 2 weeks is about that deferral. If you disallowed the costs, why would they continue to be in the deferral? They have a deferral. That doesn't mean this $153 million is in it.
Well, so again, my point is, just because this 153,158 is sitting there in that account, was it specifically after all of this stuff happened? Did something happen that said this money is still sitting out there waiting for future consideration?
No.
Just the accounting order that had the deferral, right? And I think this is what sort of buttresses our claim on what at this time means, right? If it were a true disallowance, don't come back, why would it have been deferred?
May I respond, Commissioner Thomas? Now that's a statement of fact, but if this disallowed amount was actually deferred, then we need to know about it, because that doesn't square.
I think that's all I have right this minute. Let me think about it.
I want to follow up on that. Is there anything in the 2018 rate cases? I know the rate cases had 2018 docket numbers, but 2019 order numbers that said this amount would be a deferral.
No.
So, are you referencing an order that came after the rate case for Mr. Trawick?
Can I beg the Commissioner's indulgence? So there was a deferral in the first instance, and we continued the amounts in deferral with no return on them.
Tell me, what do you mean the first instance? When started incurring these costs, a deferral was created?
So can I defer to my co-counsel on this? You might get a quicker answer for the commission.
Yes, sir.
Thank you.
Thank you, Commissioner Belzer. So initially, when the company began incurring coal ash costs, we did seek an accounting order for deferral. I can't remember the time period. I want to say 2014, 2015 timeframe. Those costs, as part of our rate case in 2018, we sought recovery of those costs. We also sought to continue the deferral for coal ash expenditures. The results of that order, the results of that commission's decision with regards to Mr. Trawick's artful arguments around at this time, in addition to the ongoing appeal of the particular decision, kept those costs preserved. The fact that the Supreme Court This affirmed the viewpoint that at a later date in time, the company would be able to seek recovery of those costs. Whether it's a regulatory asset versus a deferral, we kept those costs on our books to be able to be allowed, per the Commission's decision, Supreme Court decision, to be able to seek to recover those costs in a future matter. And throughout all of the stages of our rate cases and proceedings, we have continued to keep those costs on our books preserved to allow for the opportunity to recover those costs in accordance with Commission's decision and the Supreme Court's decision as well.
Okay, thank you for the clarification. Mr. Torrey, do you want to respond or comment?
I do, Madam Chair. Yes, they still have a coal ash deferral. They started the deferral in, I believe, 2016. So in 2018, when they came before you, like they'll come before you in a couple of weeks, they sought to amortize that deferred balance. And this commission looked at that balance and said, okay, you get everything, but you're not going to get that $153 million. So,
ORS's position is because the commission said in the 2019 order on the 2018 rate case that this is disallowed, that $150 odd million should have been removed.
correct.
Okay. I just want to make sure that I got everybody's position straight here.
And I appreciate that, Madam Chair, and sorry for not being prepared.
That's okay.
ORS had not raised that as an issue in the case.
Well, we're getting a little beyond some things.
Mm-hmm.
At the time that the the DEP and the DEC rate case orders came out, and I'm getting to the differences in the orders. Did either DEC or DEP raise the fact that one order had at this time and several times and the other one didn't?
I think here's how I would respond to that. DEC petitioned for a rehearing because one of the arguments there was that the commission had not made as robust findings in the DEC order. DEP's order, in the company's view, was more packed with facts and findings.
I'm sorry, DEP's?
DEP's was.
Was,
right.
Okay.
And DEC's, and again, because these were tried back to back and had a lot of overlapping issues, the same witnesses and things of that nature. So I think encompassed within that would be. But I mean, I think you raise a good point. I mean, why would they have been treated differently with such similar records?
No, I'm asking if DEC asked for reconsideration on that point.
They asked for more findings and did not feel that the commission's order had given the analysis there.
Okay. And the commission disagreed?
Commission disagreed, and so did the Supreme Court.
Yes. I was getting there next.
Yep.
Okay. Okay. That's all I have. Commissioners, anything further for council? For our very, Commissioner Carol Lee Williams. Start to say for our very patient council this afternoon.
I just want to add to the previous conversation to see, I don't think I've heard, was the DEP decision a product of a settlement?
Commissioner Williams, no, both DEC and DEP cases in 2018 were fully litigated.
Okay, thank you. I appreciate the clarification.
There
No
were,
further questions.
Commissioner Williams, there were partial settlements, but not as relevant to the issues here.
Okay.
Commissioners, anything further? Commissioner Thomas.
Just one more little point of clarification. So the way I understand it is the commission did not issue an order and the Supreme Court did not, in their ruling, say that this $153 million is available for deferral and consideration in the future. That did not happen. Is that correct?
Those specific words, no, Commissioner Thomas, but the Supreme Court left the door open. And I don't know how else you can read that. I mean, I know we're drilling in on the deferral here, but that's not. No, they did not. They also did not say only for costs in the future.
All right, thank you.
Commissioners? Gentlemen, anything else?
No,
I don't
Madam
want
Chair.
anybody to rehash anything, but, okay. Aaron?
No, Madam
Okay.
Chair, thanks so much for the commission's time today. Even in circumstances in which application of the law in somebody's view is clear, where facts would help further clarify the law's application, dispositive motions are not proper. And so on that basis, we'd ask that the commission defer ruling, have a plenary hearing on the merits, and decide this in the final order.
Okay. Thank you. Mr. Torrey, anything?
We believe that the law and the prior facts that don't need to be found in this case are already, they're before you, and you can decide based on that. Thank you.
Thank you, Mr. Torrey. Gentlemen, as you probably are aware, we have noticed a special business meeting tomorrow. We had to go ahead and put a notice out in case we feel like we're able to make a decision in the morning, because I think the parties are eager and need to know how to go. I am hopeful that commissioners will feel comfortable with going ahead tomorrow, so just be aware that we do have that notice out there. But I ask that be done in an abundance of caution, because I know that y'all need an answer, and hopefully we will be able to render a decision one way or another in the morning. But if not, we'll announce that too. I just want you to know that the decision was not prejudged. It was just we had to abide by to get a response quickly. And we've got some folks that are out of pocket next week, that if we are able to issue a decision tomorrow, we are trying to do that, is what it is. And we put the notice out there to comply with public meeting notices. So we will let you know one way or another in the morning if we got a decision or not. So with that, thank everybody. I appreciate y'all's attention, y'all speeding us in getting to the oral arguments. I know y'all had some short time on that, and appreciate everybody working with that. But thank y'all very much, and you have a good evening.
Thank you, Madam Chair.
We are adjourned. Thank you.